Announcement of judgment, item number 1.
From what has been discussed above, it is clear the death of the student was caused by electrocution, and the same can be attributed to negligence and deficiency on the part of school authorities who were responsible for the safety and security of the students. Notwithstanding the fact that the place of the incident was restricted and supposed to be unlocked on key, the very fact that safe was left unlocked is a failure discharge of assigned duties on the part of the concerned teacher. The findings contained in the various reports also indicate abysmal conditions of the medical system and reflects on general maintenance conditions of the institution which need urgent attention. As such, there exists serious systemic deficiencies in the school's infrastructure and supervision, which has been identified, though on the findings no criminal negligence has been established against respondent before. However, as it is reported that corrective measures are being taken, and due to the fact that the criminal case wherein the charge sheet has already been filed is pending, this court, in consideration of the entire facts of the case, while disposing of the matter, directs as follows. 1. Safety measures, including safety audits of electrical installations, such as wiring, etc., to be conducted periodically to ensure effective maintenance repair. 2. Engagement certified electricians for putting in place of proper safety protocols for electrical systems. 3. Proper monitoring and supervision of access to high risk or hazardous areas in the school, such as terraces, etc., to prevent future accidents. 4. Placement of signage indicating warning and danger signs at hazardous places. This court, in consideration of totality of circumstances, hereby orders school authorities to pay further compensation to the parents of dear Nakhil Sotun of a sum rupees 6.5 lakhs over and above the ex gratia payment of rupees 1 lakh, which is already disbursed by the school. The said payment shall be positively in a period of 8 weeks from the day of this order. My petition is disposed. Yes.
I do pledge, Lordship.
Any mention?
Please, Your Lordship, I beg to mention item number 23 minutes of the hearing list. This is that matter relating to the excise label, which was pending before the division bench of the Honorable Bombay High Court.
Yes.
Apparently, Manoj, the appeal has been allowed in favor of the private respondent. I'm instructed they're preferring an SLP against this. May I just be given 2 weeks' time, Manoj, for further instructions in this matter?
What will happen to this case then?
This is the instruction that I have, Manoj. I received this.
Is the brand being sold in the market now?
No, not yet, Manoj. As far as we are concerned, we are not selling it.
You are selling it?
My lord, I don't have any proper instruction. Let the matter come up.
After 2 weeks, Manoj, in the meantime, I'll have further instructions in the matter.
So there was a direct bearing in this case?
Correct, Manoj.
Yes. 2 weeks, yes.
Obliged,
Mr. SN submits that the connected matter for Bombay High Court has recently been decided in favor of the respondent number.
You don't have the file.
The private respondent, Manoj.
And in favor of private respondent. Such he prays we allow 2 weeks' time to obtain further instructions. Just after 2 weeks, yes.
Obliged, Manoj.
Yes.
I would like to mention item number 21, Your Lordship.
Yes. This matter is in the final stages.
Yeah, it is. Yeah. Give me 1 week time, Your Lordship.
Why?
I have some personal problem. 1 week time. There will be no further prayer for extension of time after this.
We told you to take instruction. What is the matter about this?
That is matter in 3 increments. That upgradation, my lord, it has to be adjusted. That is the issue. Lordship has heard that, right? Anyway.
1 week.
Obliged.
Possibility of Mr. Tikitatta.
Please, Your Lordship, item number 26, Your Lordship.
Yes.
Come up to 2 weeks, Your Lordship.
What is the matter about?
This is the misappropriation of the misinformation of the data regarding the pension.
In the pension?
in the pension. I'm the wife,
No,
the
no
other side the
urgency.
husband. 2 weeks, sir.
Why no urgency?
Not at the moment because it's already gone to pension, sir.
Yes. After 2 weeks.
Right.
Yes.
Item number 2.
May I please, Your Lordship? My Lord, this is the matter where a student, my Lord, was suffering from 45%, my Lord, intellectual disability, and he has got a certificate to that effect also, my Lord, from the competent authority. He has graduated from St. Edmund's College, my Lord, securing 59% the second class, my Lord, political science. Now he wanted to pursue further studies, my Lord. So accordingly, he has applied for a Master of Political Science from the Northeastern University, my Lord. And he has applied under the horizontal 5% reservation because every institution are required as per law, my Lord.
They have that quota also.
They have a quota. They should have a quota, my Lord. So, but unfortunately, my Lord, the provisional lease has come out. In the provisional lease, when the cause of actions arose when a provisional lease was published, my Lord, on
You're applied under the disability quota?
Yes, my Lord. Then on 23rd July 2025, my Lord, this is the provisional lease, page 19, my Lord.
Page 19.
Page 19. And CUT also, my Lord, I have passed. I have got 101 marks in the CUT also, my Lord. So, and my Lord, you will see page 20 and 21 is a provisional result of the opened category. And my Lord will see 22 is the first is EWS list and comes Nehu ward list, then ex-serviceman ward list. So there is no list for the special labeled persons, my Lord. So I was aggrieved. I verbally have approached the HOD of the department. They're saying that intellectual disability does not come within the benchmark. So, but my Lord, that is wrong.
Benchmark.
My Lord, Section 2R,
Will be Act.
yes, of the Act defines
Act of People with
Section 2
Disabilities.
of the disabilities
People with Disabilities.
of the Rights of Persons with Disabilities Act. Section 2R, my Lord, has got. It says, my Lord, may I read? Person with benchmark disability means a person with not less than 40% of a specified disability where...
Reading from R's mental retardation.
Section 2R, my Lord.
Yes.
Section 2R.
In the condition of arrested and complete development of mind of a person. We're reading benchmark.
Just a second, my Lord. Section 2 definitions, my Lord. Section 2 small r, my Lord.
Small r.
Yes.
This is which 95.
No, this is 2016. This has been repealed.
Yes,
This has been repealed.
So I was wondering how to use mental retardation. How is that word used in this act? I was shocked.
2016, 1995 has been repealed.
No, I know that.
Yes.
I didn't see the title. I was wondering how this term is still being used now.
May I just read out, my Lord? I'll read out slowly, my Lord. It says that R says a person with benchmark disability means a person with not less than 40% of a specified disability where specified disability has not been defined in measurable terms, and includes a person with disability where specified disability has been defined in measurable terms as certified by a certifying authority. That is one. And also, my Lord, I would fall under Section 2S also. It says that person with disability means a person with long-term physical, mental, intellectual or sensory impairment which in interaction with
before them.
I'm sorry?
On your rejection, on your
yes by not by way of representations, my lord. I have by way of oral, but then they say that we will conduct medical board, we will conduct this doesn't fall, all those.
No, they are not nobody.
Yes.
Does he have a disability certificate?
Yes, my lord. The certificate is here at page the page 12, my lord. Page 12 of my petition.
Do you think a person will misrepresent?
No, my lord. What is this, my lord? I
Why are you
received.
saying
No,
that you
I'm saying
cannot
receive this copy on. Immediately I said, my lord, perhaps, my lord, today all the information will come to me. What information I have received, my lord? We have now rejected his case. This is under consideration. This much I have received, my lord. Regarding the other detailed instruction, my lord, perhaps in the course of the day, my lord, I am expecting it in the morning. Did not happen. So his case is not rejected, under considerations. The details, my lord, as of now, my lord, I am waiting instructions.
Because
can
my
be
lord,
tomorrow, lordship.
Because my lord, once I joined, a competent authority issues.
On the premise essence,
My lord.
even obtain special instructions. This is matter tomorrow.
But till then, at least one seat should be reserved, my lord.
Tomorrow.
My lord. Obliged, obliged.
Item number 3.
Yes.
Lordship, the matter is fixed for admission hearing, my lord. My lord, let it come up after some time, my lord. At the end of the board.
Sometime means.
And the end of the board, my lord.
Let it come up. Lordship, the thing is that this affidavit is supposed to have filed they've just filed an affidavit.
That's fine.
As per the last
This is
order,
the
it's
status
supposed to be
report.
filed 3 days in advance. So this has to be communicated to the senior counsel, Mr. Borbora. It did not come today because Borbora. See, he did not come today because the report was not submitted. It was actually as per the last order.
After a week, my lord, because we have filed it today only, my lord, this report.
You are the author of the report. You need instructions on it.
So we need some time to go through this report.
You need time to go through the report. It's a 2-page report.
But I have to communicate. He's in Guwahati, so I have to go.
Guwahati, you are here.
Yes. Lordship, may I request a date if that is okay?
Dead end. So this Hari Mandal, you released him?
My lord, he has just come and given statement, my lord. He is just a laborer, my lord. Probably his Aadhaar card has been misused. That is what it has come up.
This can happen to anybody. Yes, just note down, pursuant to order dated 3/7/2025, a status report has been furnished by the state respondents only today, though it is directed in the said order that the same should be submitted 3 days prior to the date fixed for hearing. Marpan submits that as the report has been received, that he be given some time to examine the same on behalf of the concern. So accordingly, this is matter after 1 week.
11 will do.
11?
11, just request a date if 11 August.
Obliged.
Item number 4.
11 is more than 2 weeks away. 1 week.
It's just 2 weeks. 11. Okay.
May it be the Lordship.
My lord, may please your lordship.
What miscase is this?
Miscase, my lord. Miscase is there, my lord. My lord, we have filed a miscase, my lord, regarding the opening of the financial bid. My lord, your lordship was pleased to fix this case on 4th of August, the WBC, my lord. That was fixed on 18/7. In the meantime, my lord, they have opened the financial bid. Lordship may kindly come to page number 9.
Number 9.
My lord, page number 9, para 7, my lord.
Yeah.
These are the rates. The tender amount was around 66 lakhs, my lord.
Round?
66 lakhs.
66 lakhs.
Lakhs, my lord. So, my lord, the respondent, private respondent number 5, he have quoted 69.53. Respondent number 7 has quoted 71.78. Respondent number 6 has quoted 73.60. And my rate is 14 lakhs, 19,000 lesser than them, my lord. Now, my lord, on the earlier occasion, since a so-called notice was issued to me, and lordship was pleased to resolve that matter before then. So, my lord, upon the so-called notice, there was 2 grounds. If lordship comes to page 13,
Yes.
my lord, the reference says, reference number A, this says relevant tender contract hiring of so and so buses for conveyance of troops and families from transit camp from Jorhat to Morioni railway station. This is regarding another tender, my lord. This so-called notice was issued regarding another tender, not this instant tender, my lord. So, my lord, the charges which were made upon me was at para 3, A and B. It has been alleged that I have forged an certificate issued by the association. Number 1. Number 2, they says that in the year 2021 and 22, I have forged an SBI certificate, thereby resulting in your firm being penalized. That was already penalized, my lord. That issue was already resolved. Now they are bringing this point here. So to this so-called notice, what I have replied, the so-called reply on 22/7/2025 at page number 15, my lord.
Now only one thing here, Mr. Bora.
SP Das, my lord.
SP, Mr. Das.
SP Das.
Is your firm currently engaged in any transport contract with the respondent?
Yes, my lord. For last 3 years, continuously, my lord. Still going on, my lord.
And there's been no complaint?
No, but kindly, they have issued a certificate also. Come to page 6, annexure 6, page 22. Well, this is the certificate issued by them on 18 July 2025.
Yes.
This is a certificate issued by them, my lord.
Yes. So why you have come against the
opening of the financial bid in the meantime?
Yes, sir.
During the pendency of the writ petition, they have opened the tender.
Two things,
there were no interim orders operating?
My lord, first there were no interim orders, my lord. The financial bids have been opened. The work has been awarded to
Island Lalu,
my lord. Secondly, my lord, a so-called notice for blacklisting has been issued to them, my lord. They have replied to them, to the so-called notice, and we are passing order maybe by today or tomorrow. That's one aspect, my lord. Second aspect is a habitual offender. Earlier occasion also he forged a SBI certificate, my lord, saying that his turnover is 4 crore rupees, and it came out that as a State Bank says that it is not been issued by them, my lord. So taking into all these aspects into consideration, my lord.
So you're looking at his antecedents also,
my lord.
And why does he have subsisting contract with you?
My lord, subsisting contracts, they have not. There is no material, my lord, showing that there is a subsisting contract in the writ petition, my lord. So, my lord,
instruction.
My lord, permits me to file an affidavit, my lord.
You file a short affidavit within 1 week.
1 week's time.
Yes. But no interim orders, Mr. Das.
Now it will become infructuous, my lord. My rate is.
It's already been awarded, my lord.
My rate is, my lord, 14 lakhs below. That was the reason for putting me, my lord.
That is why sometimes also when the rates are too low and not competitive, then it raises red flags. It's not necessarily that now tender jurisprudence doesn't mean that just because you're the L1 that tender should be given to you. That is not you don't acquire any vested right. Even if someone gives a higher rate, it's suitability also.
But that was,
in fact, in fact, several of the contracts they have not been
I'm
able
not
to.
very happy. So let them file if they can come up with some materials. There's nothing that cannot be undone. Yes.
my disqualification was not for that reason.
Doesn't matter.
They have disqualified me earlier, and the SOCOS which has been issued, that is not regarding this tender, madam. And their own certificate.
That's not correct, madam. This is with regard to this tender only.
Their own certificate says no, madam. I'll show you.
Did he submit file certificates in this case?
Yes, madam.
No document, madam.
Let them
We will file an affidavit to bring everything on record, madam.
It's too dodgy. Anyway, Miss Case number 166, Mr. Das, that is application, has prayed for stay of the operation of financial bids, which he submits has been opened on. When is it opened?
It was opened on 22/7.
On 22/7. And apparently it has been the contract ordered to the respondent number.
Respondent number, my lord, I think 5, my lord. 5.
If that were Mosica Lizzi to file a short affidavit just after 1 week exactly.
My lord, some my lord,
6, 7, 8 are irrelevant now, my lord. The respondents.
Doesn't matter. Let them if you find objection.
Item number
If
5.
you have a valid objection, well and good.
Lordship may fix a date, my lord.
Yes, after 1 week.
All right.
Yes,
My
you
lord,
filed a jointer?
No, my lord, I pray for some time, my lord.
Why?
For another 2 weeks, my lord. Since the petitioner, my lord, she has something to add more, my lord, to the rejoinder, and she said that she will come and read first and everything. So, my lord, kindly accommodate for me for another 2 weeks.
What? Yes, MS Essential Legal Aid Council plays for a 2 weeks to file a jointer. Just thereafter.
Obliged, madam.
Highly obliged, my lord.
Item number 6.
Worship, I am appealing for reason. This is a contempt petition against the respondent. It's the gold matter, Worship, the gold bank in the matter.
Yes, but the instructions
come up to the value as well as the value at which they have disposed of.
But we have filed
I don't want to issue appearance of whoever is responsible.
But I understand, my lord.
We other institute contempt proceedings.
I understand, my lord. But only one thing, which is very crucial, this matter, my lord. During the pendency of the original writ petition, my lord, the adjudication order has already been passed against him, my lord. Now there was a direction to release the gold in the interim, my lord. That was a provisional release. Now final adjudication order has been passed, and I'll just take your lordship to the adjudication order, my lord. In my affidavit, lordship kindly says.
You file a fresh affidavit?
You filed on Friday, I think, 25/7.
You have received copy of the affidavit, Mr.
Yes,
Mr. Chatta?
yes.
My lord, kindly come to the last page on page 75.
To be ended. Yes.
My lord, at page 74, lords will see the final order, my lord. I order absolute confiscation of the seized gold bangle in semi-finished form for an origin gram, so total valued at rupees 11,70,000. Now, my lord, adjudication order is of the valuation out at the time of seizure, my lord.
Yes.
Now refunding, because the lordship who submitted earlier, the gold bangles were handed over to the RBI in terms of the circulars, my lord. But somehow it was not put in the affidavit, my lord. And that was an omission on our part, my lord. But it was nothing intentional, my lord, because the affidavit primarily confined to the issue of 180 days notice, my lord. So this aspect was not brought to.
See, look at the order 75 also.
My lord.
Order dated 9 December 2024, correct? Yes, it however pursuant to Normal Meghalaya High Court order dated 25/11/2024, I disallow the disposal of the gold bangle till the outcome of the appeal. When is it disposed of? When is the effective date of disposal? The day it was disposed of. This is 9 December 2024. And writ appeal has gone against you.
My lord.
Then when was it disposed of? While the appeal is pending?
The document.
Where? Why was it concealed from the court during the proceedings that it had been disposed of?
My lord, page 8, my lord.
82?
Page 8 of my affidavit.
Yes.
The subparagraph. In compliance with the above board's instructions, the equivalent value of seized gold in the instant case was calculated based on criteria above, that is, customs area as seizure was done in International Airport, Impal, and handing over the seized gold was on 21/9/23, and subsequently PW note was issued on 1/11/23. So somewhere around that time, my lord, the gold was seized. Gold was disposed of, my lord.
Who's the officer responsible for disposing of the gold? You just come up with the name.
So disposed of on 21/9/23, my lord.
21/9/23.
That is gold was disposed of.
Where's that? Where do you get that from? Dohata International Airport, and handing of the seized gold was on handing over, not sale.
But what happens, my lord, we simply have to deposit it with, this is called security press.
What's HOG?
Handing over gold, my lord.
Handing over
HOG, handing over of gold.
Handing over gold, HOG is called?
My lord.
Is that a procedure? Prescribed procedure, HOG?
My lord.
Where's that note?
My lord, kindly come to page 20, my lord. In fact, from page 15, my lord. These are the circulars.
Where's that HOG note? It says HOG note enclosed.
And there's some mistake in the affidavit, my lord, it seems.
That's it, HOG note. See 3.5 of your page, up page 17.
My page?
Talks about some HOG note, right? What's HOG? What's HOG? Thereafter, correcting the goal. Sorry. The form of HOG notes given in Annexure 4. Where's it? There's Annexure 4. The printed HOGS note shall be prepared and quadruplicate. What's SPMCIN?
Security press, page 20 you'll also find it.
Where's that HOGS note? Is there?
Well, page 20 you'll also find, my lord.
HOGS note.
Page 20 is the format. This Security Printing and Minting Corporation of India Limited, my lord.
This is a draft MOU. does not talk anything about the present case.
The actual one is not been annexed yet, it seems.
See, what is disturbing is that there's an order of 9 December 2024 by own adjudicating authority saying that do not dispose of the gold also.
But page 52 will also kind of similar.
We can't just grope in the dark. Who's the responsible officer? Attempt to appear.
But only referring to page 52 minute. Page 52 I have it only.
Have you seen the affidavit, Mr. Chadha? Chadha, you've seen the affidavit. Have you seen the affidavit file? You receive a copy.
Yes.
You've seen page 52.
Yes. Page 52 is of this is an actual I. It's by the office of the superintendent, office of the deputy commissioner in Pahal. This says it's a letter issuing the guidelines. So I have the submission of this. These guidelines or circulars can never supersede the statute. The statute, the Customs Act, Section 150 is very clear. Unless and until goods are confiscated, they cannot be disposed of. Section 150, if the Lordship may kindly allow me to just read the paragraph. The section 151. It says, the procedure for sale of goods and application for sale proceeds, where any goods not being confiscated goods are to be sold under any provisions of this Act, they shall, after notice to the owner thereof, be sold by public auction or by tender or with consent of the owner in any other manner. So, Your Lordship, in my case, the goods were not confiscated by way of an order. And they have disposed it of, and there is a judgment of Honorable Bombay High Court in this regard. My colleague is there in the Honorable Court, if she can provide a copy of the same. If the Lordship may kindly allow me to read one paragraph of that judgment.
No, I don't understand. Forget judgments aside or law aside. I don't understand why, even before your own educating authority also, that it was that under course of proceedings for this court, single bench, writ appeal, why it was never revealed that the gold has been sold, has been handed over to.
And that's the reason I asked them, like, why in the affidavit we didn't. Why it was already disposed of? Why it was not disclosed?
A question which leaves a very bad taste in the mouth. That's the thing.
I understand, well, I asked them. Like,
that is why.
I asked them specifically why this was not brought in affidavit. That is already.
You come before court, notwithstanding any kind of case, doesn't matter. But you can't, because see, see in by
even the adjudication order, he also does. He's not aware.
Correct. He passed his order, saying that he orders absolute confiscation. Okay, and then I just allowed it to disposal of the gold bangle. He said, I disallowed the gold bangle till the outcome of appeal. Now, this order is passed on 9th December.
It's true.
And in 2023,
so, this was not authorized in the affidavit before this honorable court, my lord. And even the adjudicator also that he is not aware about this, my lord.
It should have been brought to the adjudicator that your own officers have disposed of the gold. I think you've named, who have you named here as a.
It is the Commissioner of Customs, Mr. Mahfouz, and the Assistant Commissioner.
Madam, Mahfouz has been transferred.
So issue contempt notices, Mr. Yes.
In para 1 of the affidavit, you have said that Mahfouz Rahman is not the commissioner anymore, my lord. He has been transferred to Calcutta.
But he was the commissioner at that time.
Who? This number 2.
He was responsible. Yes,
number 2.
Number 1 was the commissioner. At that time, when the proceedings were continuing before this honorable court, he could have advised this honorable court, concealed the fact.
Yes, in the course of proceedings, it appears that the fact that the seized gold bangle measuring, weighing 193 grams,
197 grams,
had been disposed of since which date? 21/9.
21/9.
21/9/2023 had not been divulged or stated in any, or have said before this court, either at the stage of the single bench or before the matter, while the matter is pending in writ appeal. Interestingly, the affidavit filed by the respondents also discloses that when the matter was adjudicated before the Additional Commissioner of Customs, this fact, it appears, was unknown to the state adjudicating authority, inasmuch as in the order dated 9 December 2024, the adjudicating authority had disallowed the disposal of the gold bangle till the outcome of appeal number 20/2024 attained finality. In these circumstances, it appears that further orders are called for in this matter, and as such, the contemners number 1 and 2 are entitled to appear personally before this court. Which date you give?
I don't know. Number 1 has been transferred. Number 2 also I am not aware.
Will appear 1 and 2.
Well, he's been transferred to Calcutta. That's will grant me 1 week's time, my lord. I'll have instructions how to resolve the matter, my lord. If necessary, we'll file a review, my lord, bringing all those into court.
We'll have let them appear. Why they can't go scot free?
1 week's time. I'll talk to them how to.
Yes, Mr. Chadha. What do you propose? Should we call them personally to answer?
I would just request that if they are willing to give me the gold bangle, which they are sold, if in case they are sold, they give me the value as on date, I will be satisfied. I will be more than happy.
But the implication is that the adjudication order also has to be changed accordingly, my lord. If you refund the full amount, my lord, the adjudication order has to be changed, because as I pointed out, my lord, adjudication order is only pertaining to the value at that point of time, my lord.
Adjudication order has already been challenged before the appellate authority. This appeal is pending. The matter is still pending in that court.
But we're concerned about the proceedings, that how the customs conducted themselves. That is why for the
So 1 week's time, my lord.
Personal appearance.
I'll talk to them. I'll try to resolve, my lord.
The judgment of the High Court.
1 week I will try to resolve, my lord. If we are not able to resolve, my lord, then personal appearance will be directed.
Okay, score out. In the course of the proceedings, when it's been detected that the custom authorities or the respondents have clearly suppressed the fact that the gold bangle had since been disposed in 2023 itself, and as orders were being passed for the personal appearance of respondents 1 and 2 to explain their conduct. Dr. N. Mozikal and JCI prays that he be allowed just 1 week's time to clarify the matter or to resolve the issue. Stop. Next part, those court not inclined to allow the prayer made by the JCI, however, in interest of justice, 1 week's time is allowed. It's list after 1 week.
Failing is the left.
Let's fix date, yes. 4th is when?
August.
Next Monday.
4th of August.
Only one thing, failing with the life in person.
Yes, it is made to understand. It is also given. It's also the response also made have to be to understand that feeling any clarification, they shall appear personally on a date that will be fixed on the next hearing. Yes.
Item number 7.
in this matter, I'm requesting, because the learned advocate general is leading us, if the matter could be taken up tomorrow.
And of the board?
Tomorrow, my lord.
Tomorrow, my lord.
Okay, tomorrow.
Item number 8.
On the prayer of Mr. A.S. Pandey, A.S. Pandey, on behalf of the Advocate General, this is matter tomorrow.
Item number 8.
Please, Your Lordship.
With the joined
We'll be filing in the course of the day, during the course of the day.
Item number 8, 9 and 10.
The joint actually filed the court today.
Similar prayer for item number 9 as well, Your Lordship. Similar prayer for item number 9.
This on
After 2 weeks.
1 week.
2 weeks.
2 weeks, not interested in your lease anymore.
Your Lordship.
Same order number 9.
And
your item?
Number 10.
Number 10,
Your Lordship. I'll be filing. I require some more time, Your Lordship. 2 weeks time.
On number?
Item number 10.
Number 10, Mr. R.K. Sundram, please for a 2 weeks time to file the joined.
Obliged, Lordship.
11.
Yes, Mr.
My lord.
What is this?
My lord, this is with regards to the modification of the order passed by this honorable court, my lord.
Oh yes. Open a shop.
So you will see here, this petitioner is not clear about it and they are not giving the clear picture about the matter. You will see. Here you will see this in my affidavits I given, and after that they are not filing the rejoinder, and then they are not filing the rejoinder. Thus our affidavit is not converted. File this another application for vacating the order, and that's why you will see last question I said that
Vacating is for modifying.
Modification,
so
my lord.
modification.
When you put his lock, you went and put a lock over his lock.
So you will see here.
Or you put the lock over their lock, or you?
No, my lord. It was my lock, and they put it, my lord.
Your lock?
My lord.
You put the lock,
my lord,
and then he put the lock on.
Above that lock. And my lord, it was.
And that time was before status quo orders were passed, or
no? After, my lord. Status quo. I was happy because the stay order was there, my lord. Status quo order was.
Then why did you go and open the shop?
My lord, but because lock was there.
But the status quo, the lock's there. The status quo means that
both the locks were there, my lord.
Doing status quo, and status quo order was passed.
My lord. So, my lord, they themselves has admitted in para 7 of the affidavit, my lord. I have annexed in there. They said that they have taken a ground that I have verbally requested them to lock the shop. Put your lock for the safety of the, my lord. If that be so, my lord,
What kind of goods are you selling?
My lord, it's a departmental store, my lord. All types of goods, my lord.
I mean, dry goods or
dry as well as my lord, freeze.
When was the lock put? When was the shop closed?
My lord, we have filed on 25th of. They have terminated the order, my lord, on 29th of March, my lord.
The shop been closed on 29th of March.
No, my lord. Thereafter, it has been running, my lord. And suddenly, when we have filed the petition, my lord, they put the lock. Because on 6th of May, they have issued a notice for claiming a damage charge. My lord, they have not stated that it has been locked by me. So, if my case is that, my lord...
Now it's all on your word against his, it's all his period facts. How does court know?
My lord, it's...
On which day your shop was open, when it was closed, who's locked on top of who's locked?
My lord, the termination order, my lord, right?
Let's see your...
Your Lordship.
Yes.
In my affidavit, you will see, I include here.
Where's the affidavit?
My affidavit, you will see.
Yes, let's see affidavit.
You will see page number 31.
Pictures also?
You will see page number 31 in the AD card is written on this copy of it.
Yeah.
And when it is sent to this notice, reply to the notice, then from 26 onward up to 30, council did not accept this reply to the notice. It is admitted position and saying, so before that, you will see, when we give the legal reply to the legal notice, then we have mentioned about the locked.
Are you any rents outstanding?
My lord, nothing.
Okay, you dispose this matter.
So, Your Lordship, here, in this case, may I just mention, Your Lordship? Here, Your Lordship, how many shops he is having occupation? This was he not mentioned in that?
Why should he mention that? He's only concerned one shop that you locked.
My lord, that agreement I have put.
How many shops do you have?
My lord, I have put an agreement, my lord.
No, how many shops
How
are
many
running
shops
in
he is
that
having,
place? That complex.
My lord, 2 shops, my lord. It's adjacent, my lord.
One shop is locked.
My lord.
Other shop's open.
My lord.
Yes. Is Negrims?
Yes, my lord. That's a border
control.
BRO, my lord. That's Border Road Organization, my lord. Grief.
Oh, you're running where? Is in Shillong or in Umroi?
No, my lord. Shillong. My lord can come to this miscase, which modification, my lord, I have filed in, my lord.
I'm reading this is a main affidavit, correct?
Page paras, main affidavit, my lord.
1 second. So the agreement was over. It was, or the agreement is not subsisting anymore.
My lord, it's agreement. Agreement is there, my lord. That's still.
Then you have to file a suit.
My lord, agreement is there, my lord.
Where's the agreement?
My lord, Annex 1, my lord.
Awaited petition.
My lord, which is still valid till December, my lord.
Where's the date given? When was it renewed?
Page 27, my lord. Page
renewed.
My lord. Page 27.
New agreement.
26 January, my lord, on the top, my lord.
Yes.
Page 28.
Yes. Oh, that's what happened. I remember now.
Yes, sir.
You sold expired products and someone got diarrhea or something.
No.
Then?
And after that, my lord, warning letter, page 6, my lord.
Yes. You consider, you said not.
Your Lordship, when he is selling this expiry good, then so many times he didn't consider it.
See, he's selling that they have recourse to other things.
So after that, Your Lordship, even district conjunct from also penalized to him. Then also he is not rectifying, Your Lordship. And subsequently it is taken the decision to
my lord,
and then another respectable matter, Your Lordship. In 84 he is not having any renewal also, but he is keeping out. And only 60-70 one shop. It is to be
the shop. He's having 2 shops.
My lord, page 29. My lord can come to page. My lord can come to page 29.
And 8040 which is not renewed.
It was one warning letter, my lord.
You better file a suit.
It was warning letter and that in future. But thereafter,
because you see, we thought this only source of livelihood.
My lord.
That's why we pass all
Yes, my lord.
orders. Yes.
And if it is admission, para 17 of their affidavit, my lord. Para 17 of their affidavit, my lord, can look.
What does it say? Well, we'll get nowhere with this.
Page 7, my lord. Para 17.
Yes. So on your request, they locked in.
They are saying it. If that be so, I am requesting him. I want to unlock.
You receive here.
I want to unlock my.
You receive here. Let us come to this page 18 of my affidavit. Page 18
of your affidavit.
Yes, you receive.
Otherwise, we're getting nowhere. Yes.
So this is the admission of him that is selling this expiry good.
See, apologize for selling.
Then after that, you will receive this page 20 when consumer forum has imposed him this.
So this person's only made a complaint.
And then after that, this page 22. He himself
30,000 as compensation also to that person who bought the chips.
My lord, that was we had filed a appeal against that order, my lord.
You said that, see, in this last order of the consumer court, that complaints present via VC opposite parties present by the provider submit the reduced compensation review 1,000, which is also paid. You also paid that time?
No, my lord. We have challenged that order, my lord.
How does order recorded that they settle outside the court?
It was the complainant. They said that I have received it, but it was not a fact.
Where are we going with this?
So you will see here
diverting.
Yes, this is page 22. You will see page number 22. Here's
the red petitioner.
Where he has requested to extend the time and then he will vacate.
Before this court.
Page 22 you will see.
Yes, complaining. Just hear the order and then you can assess the court. Before this court. Complaining against an alleged forceful eviction from the shop premises located at
the Border Road Organization, my lord.
At the premises of the Border Road Organization at Nomansong, Shillong. Stop. Mr. Jha submits that the writ petitioner is the holder of a valid room rent agreement, which was initially entered into on 1st April 2024 and thereafter has been renewed on 28 Jan 2025 for a period of 11 months.
11 months.
11 months, and as such due to expire on December 2025. Stop. He submits that, however, an incident had cropped up whereby the same has resulted in the respondents seeking
respondent issuing
in respondent issuing termination.
No, my lord. Before that, warning letter, my lord.
Issuing warning letter
dated
6th. Dated
my lord, it's
6 March
my lord
2025, to which the writ petitioner had replied. You replied, correct?
My lord.
Yes. Had replied, and that on this complaint matter also had been taken up before the Consumers Dispute Redressal Forum at Shillong. However, I submit by the impugned letters dated 29 March and 21st April 2025, the agreements entered into with the respondents have been
cancelled, terminated.
Yes, with subsequent orders passed for the petitioner to vacate from the premises. Stop. Submitted that even notices for demurrage charges, DEMURRAGE charges, were also served upon the writ petitioner. He submits, Mr. Jha, or the legal counsel for the petitioner submits that the entire action of the respondents is illegal and has deprived them of a source of livelihood. It is further submitted that on the matter being taken by this court with order sheet. Order sheet, the main case.
27.
Sheet main case. Main case, okay. This court by order dated
29th March, 29th May, my lord.
May 5, 2025 had directed that had suspended the operation of the impugned termination order, and also further directed that status quo be maintained. It is submitted that in spite of the orders of this court suspending the impugned termination notice, the respondents have not removed the lock which has been placed over the lock of the petitioner in the said shop. He therefore prays that he finally prays that orders be passed directing the respondents to allow the petitioner to engage in the business as per the agreement till
December, my lord.
Till the expiry
of the
business, till expiry of agreement. So, Mr. R. Devnath, learned CGC, in reply, has submitted that. What is submitted?
In 84T, there is two shop. One is 84T.
That, okay, first submission that the petitioner, that is not a question of the loss of livelihood, as the petitioner is holding leases for two shops.
So you will see here in 84T he is not having the agreement renewed.
Two shop and is holding is running two shops in the premises of the respondents, and in fact for the other shop the same has been on without any valid agreement being in
so
place.
In this shop you will see 84T, two locks is there. One is by the petitioner.
84T or
which agreement, my lord?
What agreement? Which shop? Which shop? Where? Which lock you put in which shop? The shop before where you
which is in challenge
order? Which shop?
84T.
Yes, is the code at least.
So you will see.
We're not bothered about the other shop.
So you will see here petitioner his in one shop this you will see two locks is there and another only by the petitioner.
We're not bothered about two shops at all. One shop only.
No, you will see he is occupying two shops.
So you terminate both the shops?
No, one shop.
Then?
So which shop is the
Please be clear, which shop have you terminated?
It is I think it is 67.
84.2 has been the agreement has already expired, Your Lordship.
Forget 84.2. That means
the 67T. Your 67T here.
67T is shop concern.
Yes.
So then why submitting about some 84T? Who's bothered about that?
That is not in question.
So in this shop, whatever this terminated, this is in his log only. It is not put by us.
Then, my lord, there should not be any law and order.
Shop, where have you put your log over log? Which shop? Give the number kindly.
I think it is 84, you will see. 84T, you will see.
Okay, take down, score out order. Stop, take order in this case. We can't, sorry. We thought of giving you some.
May I take, sir, one reason?
Yes. Yes. This miscase has been filed for
modification.
For that, so for modification of the order dated 29/5/2025, wherein this court had stated the termination of the shop premises, termination of the tenancy of the shop premises, as also a relative status quo order to be maintained. So, Mr. Arjha submits that in spite of the orders of this court, the lock has been placed over the lock of the petitioner in the concerned shop number 64.
80.
What number of shop?
84, my lord.
84, 64 or 67?
My lord, the agreement is nothing. There, in agreement, there is no shop number mentioned, my lord.
over the
We put the login 84.
concerned shop stop. The matter was sought to be disposed of today itself, but due to the non-clarity in submissions made by the counsel for CGC, this court is compelled to pass the following order. As such, accordingly directed that the order dated 29/5/2025 should be complied with, and the lock placed over the petitioner's shop, over the lock of the petitioner, shall be removed immediately.
So, Your Lordship, in this proposed
just after 1 week, yes.
So, Your Lordship, in 84
for compliance, yes. Very good. You don't even know the shop. You lock.
Item number 12. 84, we have put the login.
Too late now. We were going to allow you to examine the matter, but sadly, you can access the phone. Yes. Yes.
The respondents are yet to file the affidavits. Your Lordship, require two more weeks.
What's the matter? Excuse me.
May I humbly submit, Your Lordship?
Yes.
Your Lordship, as per the instructions that I have, the petitioner will be returning to the duty to a school on 18 August.
She's on maternity.
Your Lordship,
leave.
she'll be returning on.
File it.
I'll file within 2 weeks' time.
You're appearing for respondent number
1 and 2, Lordship. So, Your Lordship.
Miss Barasaji, you are not filing.
It is a formal party.
Yes.
Your Lordship, I pray that the interim order may be granted, Your Lordship.
Just like that.
Lordship, we are pressed. In the last occasion also, we
pray for interim orders. You have to make out a case for a case for granting interim orders.
We have prayed.
When you file affidavit,
it'll be on board by.
How much time have you taken? Otherwise, you'll have a good case for interim orders then.
Lordship, it'll be filed within 2 weeks, Lordship.
Within 1 week. After it will be filed by respondent 1 week, interim order will be taken up on that day.
Much obliged, Lordship.
13.
I pray for 2 weeks' time. I received instructions on Friday evening.
Contempt?
No, my lords.
This is a matter related to
VC matter.
the VC, Your Lordship.
You will file in 1 week?
Yes.
Yes.
I'm praying for 2 weeks, madam.
Why?
I just entered appearance on the
Yeah,
last
for whom?
occasion. And for the private respondent, madam.
Number 6.
Number 6.
Okay, 2 weeks time is paid allowed. Expected next date has to be on board.
Wait for you.
14.
In this case, Your Lordship, our affidavit is ready. We'll file it in course of the day, Your Lordship.
Your Lordship, this matter of urgency, Your Lordship, the matter.
Filing after the course of the day, what more urgency? Meeting urgency.
Your Lordship,
This
the
matter
term.
is actually not maintainable also, Your Lordship.
The term
of the VC has
will-
not expired, and the one that we should conduct the elections.
Yes, just after 1 week, yes. After.
Oblige, Your Lordship.
Your Lordship, but the term of the. It's on the foot, Your Lordship, the term of the VC.
Then an EAG submits that after the final course of the day, just after 1 week for rejoinder of necessary. We'll take it up. Okay.
Highly obliged, Your Lordship.
15. 15.
May I please, Your Lordship, there are certain new developments which has to be incorporated. Your Lordship, may I be permitted to withdraw this instant petition with liberty to file afresh and also to approach the appropriate forum?
You are MS Somat?
Yes, Lordship.
You're with whom?
SD.
With SD. MS M Somat, non-counsel petitioner. Any objection, Mr. Yes. No. Praise Ashmir, as there are certain developments in the instant matter, he prays you not to withdraw the same with liberty to approach the appropriate forum. Yes, same objected to by Mr. H. Karwanda. Accordingly, matter stands put on withdrawal with liberty as prayed is.
Much obliged, Lordship.
For referral to the special mediation drive, item 28. 28.
Lord, I had mentioned this matter, my lord, on Friday. for referral to the mediation, because the order in this contempt is of 2023, my lord. Until date, there's been no resolution. So, my lord, if this matter can be sent to mediation.
Yes, Mr. Harana.
My lord, matter is coming up on the 31st, lordship, and an affidavit has already been prepared, lordship, and matter may be disposed on 31st.
So why? Because all your hard work won't go in vain. You go for mediation.
But in lordship, if lord pleases, we can go for mediation also.
What is in affidavit?
Lordship.
Are you resisting the prayer, or
no, lordship? We're complying, lordship. We're allowing them to. The draft advertisement will be uploaded soon, and they'll be allowed to.
The issue involved in the matter was, my lord, for special recruitment of the ad hoc employees who have been serving for more than 10 years. That order to that effect was passed by your lordships. Thereafter, my lord, for 1 year they did not comply. Now, my lord, they're seeking to have an open advertisement, my lord. Open advertisement for all, my lord. So, my lord, it really doesn't resolve the issue, my lord. Let it go to mediation.
Lordship, if I may, lordship. Yes, please. Lordship, the issue in hand is to consider the regularization of the petitioners in accordance with law, lordship. So in accordance with law, lordship, we are allowing them to relax the age, and considering with the roster, lordship.
Sericulture.
Lordship, if I may show the draft affidavit, lordship, and matter may be disposed of on the 31st.
As per of law is concerned, my lord, the latest judgments of the Supreme Court, my lord, 2024, 2025, my lord, which settles this law, my lord, that Uma Devi cannot be used as a shield, my lord, and denying, my lord.
What's the vacancy position?
Vacancies are there, my lord, as per affidavits filed by
lordship, they are, as per for the, there are 14 vacancies, and there are 15 persons who are working on an ad hoc basis, lordship. That's why we had to we can't accommodate everyone in that.
Only 6 approached this court, my lord.
Lordship may allows, I'll find this by today, and matter may be disposed of on the 31st, lordship.
Once this advertisement comes, my lord, I have to file a fresh round, my lord.
Are they revising them, or are they just...
No, my lord, they are having an open advertisement, my lord.
14 posts.
14 posts, lordship.
Open to all, my lord.
And against those 14 posts, lordship, 15 persons are working against the 14 posts, lordship.
No, there are 28 posts.
28 posts, but against those 14 posts for direct recruitment, 15 persons are working. Ad hoc persons have been working against those, lordship.
How long have you been working?
My lord, around 15 years, my lord. 15 years. With effect from 2010. Years. From 2010, my lord.
Mr. P. Nongri, we can't give recommendation if both sides don't agree. Though Mr. Nongri has strongly represented that the matter should go for mediation. Mr. Charnalang, however, submits the affidavits being filed, and the matter is fixed at 31st. Now the same may be taken up on that date for proper adjudication. Accordingly, take this back.
Deeply.
This is matter on the next date fix.
Deeply.
Obliged.
29. 29.
Lordship, this is a regularization matter, Lordship. So it cannot go for mediation, Lordship.
Why?
Because here some law is involved, and also two departments are involved. Personnel department. Lordship.
Who's the petitioner?
Mr. Day. MDEP. SDEP.
Yes, Mr. Karmi is, because they're not open for mediation. This is a matter next date fixes.
Obliged.
30.
You open to mediation?
We have no issues, my lord, depending on the respondents if they're willing to.
So they are submitting it for mediation.
Give them something, yes. The parties the pass order for mediation, yes.
My lord. Objection.
31.
This I don't think any result will come out of it. In fact, we are filing cross appeal also in this.
Filing?
Cross appeal. This arbitration matter.
No instruction.
Instruction then not for mediation, Your Lordship, because.
Yes.
Hearing 16.
Yes.
Your Lordship, my respected and learned senior can proceed with his submissions, and if it's required, then my senior from Guwahati, he'll come on VC and reply, a counter reply.
He'll come on BC today.
Yes, Your Lordship. I think right now he's having a hearing right now only.
Yes, Mr.
They've concluded the argument, but it's my reply today.
Only see one thing, just limited to, if we can shorten the whole thing, is that is there a question of voluntary retirement, and whether resignation is a right, or whether if it is the resignation is actually the resignation is at the no, whether you can keep it, whether you can deny it rather.
Well, that's only issue.
That's the only issue. If you have it's within your power to deny the prayer of the writ petitioner, then it will take how long? 10 minutes?
20-25 minutes.
Just let me take a small break. My throat is a lot of problem. Five minutes. Yes.
Prepare a brief synopsis, my lord. Before starting my argument, my lord, I'll just refer to the last document, my last flag, my lord. This is the latest instruction I've received, my lord.
It's here in the compilation.
My lord. The last flag, my lord. In fact, the last page, my lord. Also, this is dated 21/7/25.
This is
the very last page, my lord. Application so and so. I just refer to para 2. The case has been examined as per extant guidelines. It is not in the interest of government to retain an unwilling government service. However, where the government servant concerned is engaged on work of importance and it would take time to make alternative arrangements for filling the post, the resignation should not be accepted straight away, but only when alternative arrangements for filling the post have been made. After due consideration of recommendation of DG Assam Rifle and extant guidelines on the matter, the competent authorities allowed Assam Rifle to make alternative arrangements before the acceptance of resignation of Dr. So-and-so. As a further, Assam Rifle is also requested to furnish action taken on alternative arrangement for so-and-so. Time to time.
By your estimate, how long will it take to find replacement?
My lord, this is we have just received, my lord, on 21/7.
Suppose how long will it take?
You know, that what will the modality of making alternative arrangement, whether you have to advertise or seek some deputation of some doctors, my lord. So this is one aspect, my lord.
We have to hold the hearing then.
My lord.
When does he have to join MS Langstea?
Your Lordship, the joining period is not certain yet. He has to submit his proper documents first, Your Lordship.
Proper documents meaning?
Your Lordship, when they release him, because as of now they're not asserting anything. He's just hanging, Your Lordship.
So where has he got alternate employment now?
In employees state hospital, my lord. And this is at
hospital. Where is located in Guwahati?
In Guwahati, Your Lordship. It's close to his family.
Well, you see, as per prevailing, what do you call it? Or you look at across all judgments, resignation cannot be refused. But in some cases, for reasons that are, the reasons which are, what do you call it, important, then the resignation can be kept in abeyance. The authorities can keep in abeyance.
Yes, Your Lordship.
There's such time that they can arrive at a decision. That is, course, asking if how long will it take for you to make other arrangements, or when is the joining period? But that will solve everything without having to travel here and there. That they're willing to accept resignation, but only that the advice is for alternate arrangement.
Yes, Lordship.
But they were next to mail, my lord, at page 48 of their rejoinder, which says that they have to join. He has to report by 30th of June 25.
30th of June. Now we're already in
8th of July.
8th of July.
Yes, ma'am.
You have to join ESI 20th of June.
Yes, Your Lordship. Your Lordship, he's already lost Nigrams and he applied twice. He's already lost that.
But the thing is that as of today, is that post open for him? Or
It's still waiting, Your Lordship. But then he's running out of time. He's already run out of time. I think he has just few days left and they've given the ultimatum. So now he's just hanging.
Yes.
So I'll place the Larwood merit then. I'll not take much time. It's a short matter. Page 41 of the writ petition. This is the appointment letter.
41.
Page 41.
Yes.
This is dated 30th April 2009. Para 2, when the President is pleased to appoint you as medical officer in Assam Rifle in the rank of Assistant Commandant, competized, my lord. This is important, my lord. Now, sub-para A, my lord. 6 lines from below, my lord. It says, however, an officer who is not confirmed will not be retained in service beyond the minimum period of initial engagement. Now, there is stressing on this, my lord. The appointing authority, however, reserves the right of terminating the service of the appointee at any time before the expiration of the stipulated period of notice, making payment to you of a sum equivalent to the pay and allowances for notice period. So, now next page, my lord. Subpara C. The condition that your appointment as medical officer, you will be required to serve in the Assam Rifles for a minimum period of initial engagement, which is 10 years.
Yeah.
Now the phrase used is initial, minimum period of initial engagement. Well, that's the phrase used in the previous page also, my lord. So, my lord, this makes it clear that the initial period of engagement is 10 years, my lord. Then, as I pointed out, it says that you will not be allowed to continue beyond the minimum period of initial engagement if you are not confirmed. So, meaning thereby, my lord, if once he is confirmed, he is bound to continue in service beyond the minimum period of initial engagement, my lord. Now, lordship, at page 42, subpara E, my lord. On joining the post, you will be governed by the acts, rules and regulation as applicable to Group A competent officers of Assam Rifle Cadre and Assam Rifle Medical Officers Cadre recruitment rules. So, it's bound by the act and rules, my lord. Now, lordship, in my note, my lord, I have the next document, my lord. The first flag, my lord.
The first flag.
My lord. Now, my lord, the retirement age is 65 years now, my lord. Earlier it was 60 years, now it has been enhanced to 65 years. So, is our case, my lord, that once he is confirmed, he is liable to serve us till the time of his retirement, my lord. Now, I'll just refer to my note, my lord. He was confirmed to service on 27/9/2012. That is at page 43 of the red petition, my lord. So, the submission that they are not liable to serve or they are at liberty to resign any time after the initial period of engagement, which is 10 years, is not correct, my lord.
Why?
Once he has been confirmed, my lord, he'll be governed by the acts, Assam Rifle Act, Assam Rifle rules, and the regulations, my lord. Now, I'll take your lordship to the act and rules, my lord. My affidavit, my lord. I finished the affidavit, the acts and rules, my lord. Page 14 of my affidavit. Page 14. Section 3, my lord, it says, persons subject to this act.
Page
14 of my affidavit, my lord.
Yes.
Persons subject to this act. The following persons, whether on deputation or otherwise employed, shall be subject to this act wherever they may be, namely officers and subordinate officers and under officers and other persons. So we are concerned with A, my lord. He being a medical officer in Assam Rifle, he is subject to this act.
Yes. Yes.
Now, my lord, page 16, section 8 of the same act, my lord.
Yes.
It says, my lord, resignation and withdrawal from the post. No member of the force shall be at liberty to resign his appointment during the term of his engagement. B, to withdraw himself from all or any of the duties of his appointment except with the previous permission in writing of the prescribed authority.
Yes.
So, my lord, no member of the force shall be at liberty except with the permission, previous permission.
So, you're covered by A.
It is covered by A, my lord. Now, page 18, lots of candidacies, my lord. Well, section 9 at page 16 is also relevant, my lord. I'll just page 16, well. Section 9, tenure of the service under this Act. Every person subject to this Act shall hold office during the pleasure of the President.
Yes.
Now, coming to the rules, my lord, page 18 is the extract of the rules, rule 27.
Page 17.
Page 18, my lord.
Out here.
The relevant part is 18, my lord. Rule 27. 27.1 says, the central government may, having regard to the special circumstances of any case, permit any officer of the force to resign from the force before completing the term of engagement. It's not initial period of it's an engagement, my lord. The phrase, if I may submit, my lord. Provided that before.
When you mean till they retire?
My lord.
I don't think it can mean that. Anyway.
My lord.
Yes.
Well, reading together with this, he'll be not be at liberty, my lord, to resign. I'll place a judgment also.
You cannot put that proposition that no the liberty to resign. Resignation can differ from case to case and also the terms of engagement. Now he's in Assam Rifles. His initial term of engagement is for 10 years, and he has gone also for further studies on the by the help of the forces, and he has also served a bond period also. So you have to read in conjunction the bond period, which you have to work. You have to read that bond period into his terms of engagement also. That if the bond period says that you serve for 5 years, after you qualify, then 5 years more. He's done that also.
But a bond period has additional liability on him that he has to return the 37 lakh or 40 lakh rupees.
In case he does not, in case he resigns before the expiry of the bond period. In this case, that is not there.
That situation is not available.
Initial term engagement 10 years, fine, 2012. In ordinary, suppose service 22, sorry, 12 means you would have not 20 years, 22 years. You would have finished, right? Initial term engagement. He's confirmed in service. He says continues. He went for that post and for specialization. Then he's executed a bond. Then he's also, what do you call it, discharged that bond. That you look at that from that aspect. That's what this court is trying to say. Not straight, that only like the applying the act and rules. You have to look at the case as it is situated. Okay, please proceed.
So, my lord, Rule 27.1 it said, my lord, the central government may, having regard to the special circumstances of any case, permit any officer of the force to resign from the force before completing the term of engagement, provided if before granting such permission, the central government may require the officer to refund to the government 3 months' pay and allowances drawn by him or the cost of training imparted to him, whichever is higher. The central government may accept resignation under sub-rule 1 with effect from such date as it may consider expedient. 3, my lord. The central government may refuse to permit an officer to resign if an emergency has been declared in the country either due to internal disturbances, is not relevant, if it considers it to be inexpedient so to do in the interest of the discipline of the force. So primarily is covered by clause B, my lord.
Okay.
Now, so there's a further caveat to that, my lord. The central government may refuse to permit him to resign if it considers it to be inexpedient so to do in the interest of the discipline of the force. So my lord, if I may submit it, looking at the entire scheme of the Act and the rules, my lord, firstly it says that he is not at liberty, my lord.
You mean the Act and rules gives some substance is that discretion lies
with the government,
with the government or with the Assam Rifles, whether to give him or not. That's it. Yes.
And here the discretion is of the central government. The rules say that central government is the authority, my lord, to accept or deny the rejection. And that was the latest instruction that central government said that we don't want to give an unwilling person, but this was alternative arrangement should be there. Now, my lord, we have the Petitioners' Council on last date placed several decisions, my lord, which are all pertaining to CCS rules, my lord, and DOPT circulars. Our case is, my lord, we are not regulated by DOPT or CCS rules, my lord. He squarely is governed by the Assam Rifle Act and rules. And the general law will not apply when the special law is applicable to him, my lord. This Assam Rifle Act and Assam Rifle rules.
Yes.
Now, in this regard, in my affidavit, we have annexed a very recent decision of Supreme Court, my lord. So it starts from page 19 of the affidavit, my lord.
Any affidavit?
Well,
yes.
I'm starting para 23, my lord.
The provisions.
My lord, but this was a case under Air Force Act, my lord. The provisions of the Air Force Act 1950 govern the persons who are subject to it. Clauses A to D of Section 2 defines the categories to whom the Act applies.
Where are you reading from?
Para 22, my lord, page 37.
Okay. Excuse me.
I read once again, man. The provisions of the Air Force Act 1950 govern the persons who are subject to it. Clauses A to D of Section 2 defines the categories to whom the Act applies. Once a person is subject to this Act, its provisions continue to govern them until the individual is duly retired, discharged, released, removed, dismissed, or cashiered from the service under the provision of this Act. Induction into the service under Section D is upon the grant of commission as an officer by the President or appointment as a warrant officer of the Air Force. The tenure of service of every person subject to this Act is during the pleasure of the President. Matters of retirement, release, or discharge from service are governed by the prescriptions contained in the rules. The provisions of the Air Force Act 1950 are necessary concomitant of the intent of the Parliament and to establish Air Force as an armed forces of the Union. As members of the armed forces who are subject to the provisions of the Act are governed by the rigors and discipline of the force. Indeed, that is the rationale which underlines Article 33 of the Constitution, which empowers Parliament by law to restrict, abrogate the provision of Part 3 in their application inter alia to the members of the armed forces. The purpose of these restrictions is to ensure the proper discharge of duties and the proper maintenance of the discipline. Entry into and departure from the service of the Air Force is in terms of the above provisions and not a matter which lies at the sweet will of a member of the Air Force. The provisions contained in the Act for commissioning, tenure, and cessation of service reflect the need to maintain the discipline and efficiency of the Air Force. The organizational efficiency of the armed forces of the unions is of paramount importance. It is in this background that the provisions which are contained in the human resource policy must be evaluated. So, my lord, what the Supreme Court has said that it is, and further the Assam Rifle Act very clearly says they are not at liberty to resign, my lord. And this is what the similar provisions were interpreted, my lord.
Everything has to be looked at a case-to-case basis. You can't generalize the law. The law says fine. Now, even the Supreme Court has not clearly defined. So the provision contained Act for commissioning, tenure, and cessation of service reflect the need to maintain discipline. Fine. Organizational efficiency of the unions of paramount importance as background provisions which are contained in the human resources must be evaluated. So fine. So if you have human resources or HR in your organization, that means how you evaluate a person on a case-to-case basis. Right. That's all. So in this case, we have to argue along those lines that he is not entitled to the luxury of being allowed to resign. That if the discretion lies with you, that's the only thing here.
Now the second aspect, my lord, even that is covered in the same very judgment. It was submitted by them that this petitioner is not a bonded labor. He cannot be treated like a bonded labor, my lord. And he referred to several reasons. Some of the labor tribunals, my lord, under the labor laws, some under CCS rules. Now, in para 31, if I may just read one para, my lord, on this.
Or judgment.
My lord. Para 31, my lord. Paragraph 18 clearly indicates that the general principle of service law, which has been applied to the civil services, does not apply in the situation of Air Force. In matters relating to civilian employment, particularly in the civil services, voluntary severance of service may either be in the form of unilateral or bilateral act, where severance follows on the basis of a unilateral act by an employee, no acceptance of the request for severance is required. On the other hand, where a severance contemplates is bilateral in nature, the request for an employee for severance becomes effective only upon its acceptance by the employer. In the context of service jurisprudence, the principal law which has been enunciated in the recent court is what where an employee tenders a resignation from service with effect from a future date. So basically what the Supreme Court has said, my lord, that CCS of the general principles of law will not apply to armed forces, my lord. Now, my lord, in this legal backdrop, my lord, now the situation is whether the department was right or wrong in rejecting his resignation, my lord, or not accepting his resignation. Now it's not a case that we have outrightly said that we are rejecting. In the facts and circumstances, because there are only 3 orthopedicians, my lord, in the entire Assam Rifles, and we have a force of 70,000 serving personnel, my lord.
But as per your requirement of personnel or of doctors, orthopedic surgeons don't figure anyway. That is, there has to be a cadre strength of, this number of orthopedic surgeons on duty at any point of time. That has been pointed out by the petitioner. That has been the case. That okay, there should be ENT this much, should be gastroenterologist this much in the base hospital that should be on on the roll or cadre strength. If that is the case, then yes, that maybe you can justify that. Oh, there is a need because the cadre strength, the orthopedic surgeons is maybe 3 in that composite hospital, and if this repression leaves, there'll be only 1 or something like that, or 2.
My lord, he has gone on this specialization in Assam Rifles Kota, my lord, from the Army Medical College. We expected he'll come back and serve. Of course, the 5 years is a mandatory period. But beyond that also, there is a legitimate expectation of the Assam Rifles also that he'll continue to serve. The moment he completes 5 years, my lord, even without waiting for the completion of 5 years, he tenders a resignation. My lord.
He's driven by the circumstances, he's not gone to get better pastures. For him, it's by his whatever domestic issues. See, if suppose a person gets a better employment somewhere else, then it can be like a case of, like he's just an opportunist, like a soldier of fortune. But in this case, he's a commandant right now.
He's a commandant.
Rank of commandant in the forces. Now he's prepared to go as a senior resident. Or what he's going as a?
He's going as senior resident, Your Lordship.
Senior resident, imagine.
Esik, I think he's going as in some different post. In Nigrims it was.
Imagine he's prepared to go senior resident. Taking a big, taking a big fall in his career. In his case, it's not a question. That's why you have to look at it from that aspect. It's not a question of a career prospect on the part of the petitioner. He is driven by his circumstances to request for resignation. That is why.
Well, the difficulty what Assam Rifles is facing, what they told me is that
don't have any orthopedic surgeon now if he goes. How many do they have?
There are 2 more.
Officer here was present. We can give the information.
Officer is not here today.
Yes.
So, my lord, because since there is a latest instruction, my lord, if some time frame is given.
How long can you get? But when you have to join in ESI? Yes, Mr.
That 30th June is already past.
Yes.
Your Lordship, I have already prayed for a time, and that is still on hand, Your Lordship. That might get cancelled any moment. Your Lordship, let my respective senior complete his submission.
No. Listen. You have not followed the hearing from the beginning. The thing is that now the orders come from the central government that if they arrange a replacement, then he'll be allowed to withdraw or resign from service. That is instructions given today. So that's why this court is asking what is the possibility of getting a replacement at the earliest, and when should you join? That's the only thing.
That date was 30th June.
Okay,
fine.
But just to
the thing is that
to balance the things, my lord, if your lordship will dispose of the matter, because these instructions are already there, the Assam Rifle will make full endeavors, my lord, to get an alternative and release him from service.
Yes. See, I think is he aware? He's not aware of these instructions, correct? He's not aware. You only sent it to him.
Yes, sir.
You see the last letter. Dated
21st July.
21st July. We will dispose of the matter then.
Without a strict time frame, my lord, but we will make earnest endeavor, my lord, to
work
in that line, my lord.
No, Your Lordship, may make full submission, Your Lordship. Your Lordship,
he'll get many opportunities. He is an orthopedic specialist. But he has served for. He served for 16 years. At least he has to.
One thing. What is his name? What's his name?
Yes, Your Lordship.
What's his name? I forgot the counsel's name, sorry. Mrs. Singha, right?
Rana Singh.
Yes, Your Lordship.
See, the law, to the understanding of this court as it stands, is that, okay, there might not be a right to refuse resignation, but there exists the right of the respondents to keep in abeyance. There's a long train of judgments you've seen. It's like that. Okay, they won't refuse your resignation, but they want to keep it in abeyance until until they get a replacement. But then let them get a replacement within 2 weeks.
Replacement. My lord, he has to be fair. He has served the department. He started his career from Assam Rifles, my lord, in 2006, my lord, 2009. 16 years he has served, my lord. At least he has to be a little obligated towards the Assam Rifles also. My lord, what I am praying that the matter may be disposed of with the direction that earnest efforts will be made by Assam Rifle to get a replacement and release him at the earliest. But without fixing a time frame, because we do not know, my lord, whether somebody.
How many orthopedic surgeons are there in the Comprehensive Hospital now? How many orthopedicians or orthopedic surgeons? He's orthopedic surgeon, correct? How many surgeons are there?
Total 3, my lord.
There are only 3 now. There are 3 there.
Total 3 including him, my lord.
Then it's all right if he goes.
But there are 3 full-fledged hospitals, Assam Rifles.
In all the 3 there are only 3.
Yes, ma'am.
In all the 3 combat hospitals, Assam Rifles, there are only 3.
Only 3 orthopedicians we have, ma'am.
In the entire
Assam
force.
Yes, ma'am.
Is that correct?
Yes, ma'am.
Strange.
He wants to leave with the
Assam Rifle was functioning. The Assam Rifle was functioning without me. It is functioning with me. It will function without me. The only thing is that the DIG has taken it with personal egoism and is not allowing me to go, Your Lordship.
Don't bring that in.
No, this is not an instruction from DIG, my lord. This is instruction from central government.
Can a force of 6,000 sustain only on one person? Is it an acceptable argument, Your Lordship?
It is not that, Mr. Singha. That's not
Yes,
the argument.
he has no right.
It says that
we are giving concession.
When you are governed by the rules, specific rules, Assam Act and rules, whereby there is a provision where they can refuse your resignation on grounds of expediency or grounds of requirement. They can refuse it or keep in abeyance. Now finally the instructions have come that they don't want to retain an unwilling common servant. Correct?
Yes.
So is engaged one way, it would make alternate arrangements of filling the post. If you work, so the thing is that make alternate arrangement, but let him resign then. But the notice says that the instruction says resignation should not be accepted straight away, but when alternate arrangements for filling the post have been made. Arrangements, not that is filled.
Arrangement will be
arrangement means
filling up. Maybe on deputation, my lord.
Yeah, stopgap arrangement you make.
Arrangement. So
we'll have it day after tomorrow. You come back instructions. What arrangement you're going to make? Yes, and then we'll close the matter. Yes, today Dr. Mbozikala DSTI has placed before the court a communication dated 21/7/2025 issued by the Ministry of Home Affairs, whereby the case of the petition has been examined and it has been given therein that the resignation should not be accepted straight away, but only when alternate arrangements for filling the post have been made. Stop. On this set of instructions, Dr. Mbozika directed to obtain specific and fine instructions from the respondents as to the
time period,
as to the minimum time required to float such advertisement or to make other arrangements on deputation. Yes. List day after tomorrow.
Extra one day.
On Thursday, okay.
Highly obliged, Your Lordship.
We dispose of that way. We'll have Thursday.
Your Lordship, Thursday I have some personal problem. Can it be on Wednesday, Your Lordship?
It might be too short for them to get the entire process to get instructions. Then take 1 week, Monday. We'll close on Monday positively. The matter is shall endeavour to dispose of the matter next year positively.
17. 17.
Who's state?
My lord, this Mr. Shulai had to go for some family emergency, my lord. He has informed that this matter, if the parties agree, we can be sent to the mediation, my lord.
There's no. We are challenging the appointments, my lord.
Who's upon your appointment? Mine. You're ready for mediation and lose your job in the process.
The total 5 appointments were challenged, my lord, but I don't know, my lord, yes.
Can you for mediation?
Mediate it, my lord, because the petitioner herein, he is stopped by the doctrine of estoppel. He has not participated in the recruitment process. There's a 2 advertisements.
Then we'll hear it then.
Yes.
As this reported that Mr. Andy Shulai is having personal difficulty. Yes, when?
Next week.
After a week, Your Lordship. 17, 18 and 19, Your Lordship, are connected matters.
17, 18, 19? Connected.
20, my lord, 20 can be sent for mediation. Why? Because there's a salary matter, my lord. We have not been teaching are not paid, my lord.
If it's linked?
It's linked.
It's linked, also.
The teacher whose appointment is under challenge, my lord.
My lord, in that case, because for the past 2 years, my lord, I've
not been paid.
Not been paid. Therefore, my lord, then I have a strong objection to the adjournment, my lord. We can hear it because my lord will recollect.
So you go and collect Mr. Shulai from a family emergency, and we have a hearing.
Salary matter.
Court has no problem, Mr. Yuban, to hear the matter. But if the councils are, they have difficulties, it accommodates. That is why we should. When we are here only, we hear the matter. What difference does matter A, B, C make?
But only the salary can be. Can
2 years you've gone out salary for 2 years now. You can't wait another 1 week.
Oh, my lord.
Within 1 week you'll die itself. You mean? You don't get a salary. Then we appreciate that's why.
Hello,
3 and 8, we can declare the exam.
Yes.
My lord, a similar submission.
Why?
My lord, AAG has actually informed that this can also be tried to send to mediation. But if they are refusing, my lord, we can have this next week, my lord. There's a bereavement in the family, my lord. So mediation.
Okay.
Yes, mediation.
Okay, 1 week, yes.
Can we send to mediation?
We are offering for mediation. It's up to the petitioner and the private respondent.
It's not linked to other matter, right?
No, it's not linked.
This can be sent to mediation.
Then, my lord.
The parties will have
24.
Mediation.
This pertains to the salary of the registry, Your Lordship. Now, today is the date fixed, scheduled for meeting.
What transpired during the hearing and what the government has done is, my lord, I'll just point out, Your Lordship.
We are not. What is that?
Totally different.
Totally different, my lord. What transpired during the hearing was, my lord, that the government will have a dialogue with the registry, my lord. Now, what they have done is, Your Lordships, first page is Your Lordship's order. After the order, Your Lordships will see a committee has been formed.
Yes.
This is dated 7th of July.
Yes.
Are you aware of this?
So they have notified this committee, which reads, my lord, in pursuance to the High Court of Meghalaya, Shillong order dated so and so, the Governor of Meghalaya is pleased to constitute a committee to decide on the representation of the staff so and so, my lord. Now, the 3 petitioners, my lord, have been included. Now, my lord, we cannot sit in the committee to decide our own representation, my lord. The government is supposed to approach the registry, my lord, through the registrar, my lord, and have a dialogue with the High Court, my lord. This was not what transpired during the hearings and the judgments of the Supreme Court. The learned AG made it.
This is the wrong nomenclature, Mr. Nombri, if I read it correctly. You decide on the matter as well, not a representation.
Now, my lord, this morning we attended the meeting, my lord. My lord, we were asked for the recommendations of the Honorable Chief Justice. Now, my lord, that the Registrar General will be having. We won't have the authority.
The thing is that you want this committee to be reconstituted.
Yes, they have to approach the Registrar General, my lord. We as petitioners, we are not authorized, my lord. The dialogue is, my lord, with the High Court, not with us individually, my lord.
Yes, take down.
On the last occasion, Your Lordship, in para 6 of your order, Your Lordship, 2 senior officers from the registry were supposed to be nominated. And one, Mr. Ronald Harsati, was also allowed to be in the delegation. So I don't know how they formed this. I came to know.
Who is the senior member?
2 senior officers.
Senior officers is Tapira Rinja and...
Yes, my lord. The
Sarki.
Joint Registrar and...
Who's the non-judicial member who's the highest ranking here now serving?
Not Commissioner and Secretary, Lord.
No, non-judicial in the sense from the registry. He's senior most.
She's senior most, Lord.
Dafira Rinja appears.
So that is why, as per the order, you see.
But, my lord, the submissions made by the learned AG is that the government will, my lord, approach
a small application
for modification, my lord.
Well, not modification for constituting a, for roping in Registrar General. He'll be the person in the custody of all the records and recommendations. But this there's gone as per the order. Nothing wrong with this. You see, the order says that the police are given liberty to nominate 2 senior officers among the police to represent them.
And Ronald.
So you nominated these 2 people.
Yes, my lord.
That is the thing.
That is not the issue. The issue is, my lord, there was a...
Fine, the issue is not issue, but then we have to have a proper committee in place before you come to any, positive finding.
The names of these petitioners they were supposed to be part of the delegation along with the Registrar General, not from the government, my lord. We can't decide on our own representation.
We can have a dialogue. No?
So for dialogue, you have to approach the...
They also, you see, the thing is that they have gone strictly with out of this court.
Correct,
That is why.
Yes.
They also are apprehensive. Suppose they include someone else, then there will be objections. You file a small application, and then you see.
Because otherwise, my lord, we'll have to again go for hearing, my lord, because this was not what was argued or submitted by the learned AG.
Contempt please will have to put in a small application for a reconstitution of the committee, which has been constituted, right? Order dated
29th of May.
7 July.
Oh.
2025. Yes. Nothing wrong with the constitution. Yes.
Deeply obliged.
24 and 25 are the same age. Connected matters.
And 7.
May I please, Your Lordship, this is a matter where, my lord, NOC is required from the department for my education purpose, my lord. So, on the last occasion, my lord, direction was given to the learned senior to take instruction on my additional affidavit.
You can't allow.
Well, this is not in terms of the rules, my lord. Rules do not permit, my lord.
What about the BSF person not to go?
But there are 2 aspects in that, my lord.
You don't allow, now you don't allow resignation, you don't allow even study leave. What happened to the forces now? They can't improve themselves also. They can't leave the force also. So what will be the condition then?
Well, because security scenario, man.
They remain ignorant for the rest of their lives.
Only thing is this, my lord, if I am not promoted, my lord, I will stuck there, my lord, forever. So promotion, my lord, to consider my promotion is my right, fundamental rights, my lord.
Only right to be considered.
Yes, my lord.
But here what happened, my lord, I'll just take your lordship to the rules, my lord.
This is the rule. Since they are not considering, my lord, that part, that since it was given to the electrician, my lord, diploma in electrical, I am for this diploma in civil engineering, my lord. So let me place my case, then my learned senior can argue the matter, my lord.
Yes.
My lord, I was appointed in on 1st June 2015, my lord, and I have completed a period of 10 years for consideration under Rule 50 of the CC Act, my lord. And my lord, my next promotion post is the post of SI work, my lord. Qualification which is required, my lord, 10 years, and having diploma in civil engineering, my lord.
Yes.
My lord, petitioner has filed an application.
Yes.
On Annexure 2, my lord. On the basis of that, my lord, on page 28, my lord, by letter dated 4th April 2024, I was informed.
4th April 24?
Yes, my 4th April 2024, page 28, my lord, Annexure 2.
Yes, AICT.
Yes, my lord. So by this, my lord, I was informed, my lord, that they are willing to give me admission for a diploma course for a period of 24 years, my lord.
For a period of?
For a period of 24 months, my lord.
It's 24 years.
Sorry, my lord. 24 months, my lord. That is 2 years, my lord, diploma course.
Yes.
Then, my lord, for this, my lord, Annexure 3, I have written, the type copy is in page 32A, my lord. I have written to the Inspector General, Frontier Headquarter, Borders Security Force, Shillong, via letter dated 31st/7/2024, my lord. At that point of time, my lord, I have completed 10 years of my service.
Yes.
And I have informed, my lord, that I am interested for the course, my lord, under section 50 of CC rule, my lord. I am also entitled. So then, my lord, my file was processed, and they have rejected and returned 2 times, my lord, prior to this rejection, my lord. They have informed me, my lord, these are the documents which are required initially. Then I have submitted those documents, my lord. Then they said, my lord, that my granting of NOC to me, my lord, will be subject to the fulfillment of certain criteria, which is on page Annexure 5, my lord, page 35. This is a letter which was addressed, my lord, to me on 5th August 2024.
One second.
5th August 2024, Annexure 5, page 35, my lord, whereby, my lord, certain terms and condition was enumerated, my lord, where I was asked to fulfill, my lord, this criteria. And if, my lord, kindly come to page 36, my lord.
One second.
My lord, excellent, sorry.
These are conditions for grant of study leave?
Yes, my lord. These are the documents which are supposed to be enclosed, my lord. And if, my lord, may kindly see 36, my lord.
36 or 37?
36, my lord. In view of above, application along with all annexure in RO number so and so, Head Constable Fitter Gopal Kumar of this headquarter are returned herewith with a request to inform individual according to apply for permission for higher education in accordance with the guidelines of so and so as mentioned above, please. So I was asked to comply with the guideline, my lord.
This is dated 14 August.
This is dated 5th August, my lord, 2024.
No, but it's written 36 is in the bottom is.
No, it is 4th August probably, but the letter was typed on 5th August. Please refer to ION number dated 5th August 2024, my lord. Or maybe it is signed on 14, my lord.
Yes, 14.
Yes, my lord.
Yes.
Thereafter, what happened, my lord? On Annexure 7, my lord, page number 37. 37, my lord. I have again page 37. Annexure 6, my lord.
Yes.
Again, I have addressed a letter to the Inspector General, Frontier Headquarter, BSF Shillong, my lord, with a request, my lord.
Yes.
To grant me NOC for the above course as well as 24 months study leave for pursuing the said diploma course with effect from 16/9/2024, my lord. And I have also given an undertaking, my lord, that is on page 38, my lord.
Okay.
Then my application was forwarded, my lord. Till then, my lord, they have never mentioned that my category, my lord, doesn't fall under section 50 of the CCS rule, my lord. Now, page 39, my lord, they have forwarded my application. Now, page 40, my lord, from my department, they have sent, my lord. Here, my lord, please enclose, please.
To whom?
This is from the office of the Inspector General, my lord.
Forwarded to? To whom?
To the establishment branch, probably, my lord. Establishment branch.
How can it serve?
This has been by the Deputy Commander, my lord, WAP, under whom I am serving, my lord.
Okay. Yes, then?
Then, my lord, by this letter, my lord, they have informed, they are informing, my lord, that a relevant document submitted by so-and-so of this headquarter for your information, for the information and favorable action, please. Now, my lord, my application was forwarded from the department where I was working, my lord. Now on page 41, my lord. Page 41, my lord. Yes. Now they are saying, my lord, this is page 41, the annexure 8, my lord.
Some documents are missing.
Yes, my lord. Now there, I have submitted those documents, my lord. While annexure 10, my lord, they informed me that my application was rejected, my lord. It is on page 44, my lord, type copy. This is the translate copy of the Hindi version, my lord. 43 is the main copy, my lord. It's in Hindi version. The translate copy is in page 44, my lord. If I am permitted to read, my lord, with reference to the subject, with reference to the above subject, the applicant's application sent by you, in which you had sought study leave for producing diploma in civil engineering for the academic session 2024-26 from so-and-so university, has been rejected by the competent authority for not fall under the rules for study leave. This is their case, my lord. Now, my lord, I would like to take, my lord, to section 50 of the rule, my lord. See,
yes.
If my lord may kindly peruse section 50 of the CCS rule, my lord, study leave, chapter 6.
It's annexed to the
The one you gave me.
page 34.
Now, my lord, I am relying heavily on section 50, clause 1, my lord. Subject to the conditions specified in this chapter, study leave may be granted to any government servant with due regards to the so-and-so of public service to enable him to undergo in or out of India a special course of study consisting of higher studies or specialized training in a professional or a technical subject. Now, I am in technical subject, my lord, having a direct and close connection with the sphere of his duty.
Yes.
They have rejected my application, my lord, on the proviso. If my lord may kindly see the proviso on the next page.
Which was A, B or C?
Proviso B, my lord.
Okay.
Provided further that a medical officer, I am not a medical officer, my lord, may be granted.
Second proviso has 3 parts.
Yes.
Second proviso, you mean?
Yes, my lord. They, if my lord may kindly produce their affidavit.
When you come to the second proviso, what does it say?
It says about a medical officer, my lord. I am not a medical officer. And if my lord kindly see the third proviso also, specialist or a technical person may be granted study leave on merits of each case for the postgraduate course, my lord. I am not for the postgraduate course, my lord. I am only in diploma, my lord, of 24 months. If my lord may kindly produce the affidavit filed by the respondent, my lord.
No, rejection doesn't say anything. It just says not following on the rules.
Rules, yes, exactly.
What do they mean by that?
But they are saying that it is not within the rule, permissible rule. But I have shown, my lord, section 50, clause 1. they have the power to grant me NOC, my lord, and I am entitled for that, my lord. My lord may kindly see the affidavit. After thought, what they have written, my lord. In the impugn order, they have not mentioned anything.
Which paragraph?
Para 2C, my lord. If my lord kindly considers the 5th line.
Page
3, my lord. Clause 2C.
That thereafter?
Yes, my lord. Thereafter, the petition, if my lord may kindly produce the 5th line, my lord, the same was examined and it was found that the application was not enclosed with the necessary document, including technical clearance of so and so, specific recommendation of officer in charge of engineering branch in purview of the rule 50 regarding study leave of CCS rule, and a copy of letter regarding the approval of so and so in respect of so and so, my lord. According to the application of the petitioner was again returned back. That is the first return, my lord, when I was asked to enclose the documents. Here also, my lord, they have not mentioned anything that I am not entitled. They should have rejected on the first instant, my lord. Now, my lord, may kindly see page 4, my lord. Para E. That the petitioner resubmitted his application on
not covered which way? Please show. What did he say?
They are saying, my lord, para G, my lord. Para G. Page 7, my lord. That in the present case, the petitioner has applied for study leave for undergoing diploma in civil engineering from so and so university for duration of 24 months without specifying as to how the same is in the public interest. Further, it is also important to mention that as per rule position mentioned above, study rule may be granted to the government servant with due regards to the so and so public service to enable him to undergo in or out of India a special course of study consisting of higher studies or specialized training in a professional or a technical subject having a direct and close connection with the sphere of his duty. Then, my lord, may kindly see the next paragraph, the next page, my lord. In case of head of the department or the secretary to the department or minister concerned classified that the course of study shall enable the specialist of the technical person, as the case may be, to keep abreast with modern development in the field of his duty. Now, my lord, the relevant paragraph that they have enumerated, my lord, in their affidavit is in page 12, my lord.
Page 12.
Yes, my lord. However, the case of the petitioner does not fall under such eligibility as laid down in the above mentioned rule, as he has applied for diploma in civil engineering, whereas in case of technical person, same is entitled for producing of the postgraduate course only.
Okay. Yes. However, the case does not cover. Yes.
However, the case of the petitioner does not fall under such eligibility as laid down in the above mentioned rule, as he has prayed for diploma in civil engineering, whereas in the case of technical person, same is entitled for producing a postgraduate course only, my lord. They are talking about postgraduate, my lord. But if my lord may again produce rule 50, clause 1, my lord, they have not mentioned anything about postgraduate, my lord. His technical subject, they have specifically says, subject to the conditions specified in this chapter, study leave may be granted to a government servant with due regards to his, and then, my lord, last line, a technical subject having a direct and close connection with the sphere of his duty.
Yes.
Now, my lord, if my lord may produce my additional affidavit in annexure 1, page 5, my lord. the type copy.
Additional affidavit or the reply?
Additional affidavit, my lord.
Yes.
Page 8, my lord. They have given the NOC for electrical engineer, my lord, to a particular person in the year of 2015, my lord. And thereafter, my lord, there was no such amendment in the rules, or there was no such notification by which, my lord, I am barred. They are not saying, my lord, that I am barred. They are saying that you doesn't fall under the category of 50, section 50 of CCS rule. Whereas clause 1, my lord, specifically says I am entitled, my lord. Now, they have also not sworn an affidavit, my lord, to show, my lord, that under this clause 51, that you are not entitled. And no other person has been given. There are a number of cases, my lord, where individuals from the BSF has been granted NOC for producing their education, my lord.
Yes.
If my lord may kindly produce, before I wind up, my lord, my addition, rejoinder, my lord.
Yes.
My lord, may kindly use page 6, my lord. Communication serial number 1 dated so and so. The same was acknowledged, and further it was stated that the petitioner was free from clearing and was not required for any COI, SCOI, so and so as witness. The list of reference files enclosed would clearly reveal that the petitioner has duly submitted all the required documents to the respondent. Thereafter, by communication dated so and so, the petitioner applied for study leave was favorably recommended for consideration and forwarded for further process by the FHQ Engineering Directorate. Subsequently, so and so, my lord, issued by the engineering branch, it was stated that certain documents, information being the number 1, my lord, session of diploma, number 2, number 3, my lord, till 5 were not found, and number 5, my lord, frontier IG recommendation were not enclosed, and hence it was directed to grant the study leave may be accorded subject to the submission of the said documents at the time of the granting of NOC.
You submitted all the requirements.
I have submitted all the requirements.
But they again rejected it.
They have again rejected. Now, my lord, my case is this. If I was not entitled under section 51, my lord, they should have asked me, they should have informed me at the first instant. Not that, my lord, after I fulfill all the criteria, now they suddenly wake up and they say that, oh, under 51 you cannot be considered. Moreover, my lord, I will also pray, my lord, I will insist for the record to be placed, my lord. If record is placed, my lord, it will be more clear that from...
Record must be available to the officer over here.
But if the record is placed, my lord, it will be more clear.
Why? Why you don't record?
Because as per my information, my lord, under whom I am working, my lord, they say that my work, if I get the diploma, my lord, it will be within the sphere of my work. They are saying in their affidavit.
Fitter now.
Yes, my lord.
Naturally.
So they are saying this, my lord, that there will be no public interest if I go for studies, my lord. But there will be, my lord, definitely. Because my knowledge will go high, my lord, and I can deliver more for the department only. So if the record is placed, my lord, it will be more clear, my lord.
But it will be cogent. Why you are refusing his study leave?
Yes.
Yes.
I'll reply to my senior if anything is there.
Yes.
But I'll once again draw lots of attention to the rules, my lord. Rule 50 and 51, my lord.
Rule 50 and
51, my lord. Rule 50 says, my lord, First, I'll refer to Rule 7, my lord. Rule 7 says right to leave. 1. Leave cannot be claimed as a matter of right.
Where are you reading from?
Rule 7.
I have an extract of 50 here.
Well, I've annexed with my affidavit, if lots of kindly. My affidavit, page 33.
Page 33.
33.
Yes, right to leave.
Right to leave. Leave cannot be claimed as of right. When the exigencies of public service so require, leave of any kind may be refused or revoked by the authority competent to grant it, but it shall not be open to that authority to alter the kind of leave due and applied for except at the written request of the government servant. So now next page, my lord, conditions of grant of study leave. Sub-rule 1, my lord. Page 34.
Yes, yes.
Conditions for grant of study leave. Subject to conditions specified in this chapter, study leave may be granted to a government servant with a due regard to the exigencies of public service to enable him to undergo in or out of India a special course of study consisting of higher studies or a specialized training in a profession or a technical subject having a direct and close connection with the sphere of his duty. So the emphasis on close connection with the sphere of his duty, my lord. Now, sub-rule 3, my lord, of the same rules. Study leave shall not be granted unless it is certified by the authority competent to grant leave that the proposed course of study or training shall be of definite advantage from the point of view of public interest. It is for the prosecution of studies in subjects other than academic or literary subjects, provided an officer of the Indian Economic Survey will not applicable, my lord. Subpara 3, my lord, provided also that a specialist, Lordship's got it.
Yes.
This is subpara, my lord. Provided a specialist or a technical person may be granted study leave on merits of each case for prosecuting a postgraduate course of study directly related to the sphere of his duty in case the head of the department or the secretary to the department or ministry concerned certifies that the course of study shall enable the specialist or the technical person, as the case may be, to keep abreast with a modern development in the field of his duty, improve his technical standards and competence, and thus substantially benefit the department or ministry. So this is the requirement, my lord. Now coming to Rule 51, my lord, on the next page, page 36.
Yes.
There's a time limit, my lord. Maximum amount of study leave. Rule 1 says, my lord, the maximum amount of study leave which may be granted to a government servant other than Central Health Service officers shall be ordinarily 12 months at any one time, and B, during his entire service 24 months in all, inclusive of similar kind of leave of study or training granted under any other rules.
He's asking for 24 months only.
He asking for 24 months. Now, my lord, why he's asking for leave is he wants to apply for the higher post.
Yes.
This is the recruitment rules for the higher post. I'll kindly see.
So you're only saying that he'll have 2 years diploma, not 3 years.
But the requirement is of 3 years diploma. He requires a 3 years leave. Now he is not, under the rules, he is not at all entitled to 3 years leave. At the most, he is entitled to 2 years leave.
I'm asking for 2 years only.
I'm asking for 2 years. 2 years leave is without any use, my lord, because he requires a 3 years diploma to apply for the post of sub-inspector.
That's his bad luck. I think he'll give you better service then.
But my lord, we are not obliged, my lord, to grant leave for a degree, my lord, which is of no consequence, my lord.
Border Security Force Head constable. Yeah, head constable now.
Yes, my lord.
Carpenter, mason, plumber,
He's a fitter, my
welder, pumper, or fitters. Yeah, okay.
And having 3 years diploma in Civil Engineering Institute, then only he'll be eligible to apply for that post, my lord.
No, but then what post for this fitter post?
No, my lord, this is sub-inspector, my lord.
He says already a fitter. Are you head constable now?
Yes, my lord.
He's
I'm
head
head
constable.
constable.
Then?
On the previous page, my lord, can you see? He wants to apply for the post of sub-inspector works, my lord. Column number 1.
His appointment.
Work means
His present appointment.
So maximum leave is entitled to is 2 years. In one go only 1 year.
So they'll give you 2 years.
Yes, I'm ready for it, my lord.
But my lord is a paid leave, my lord, and the department is not willing to give him a paid leave for something which is
redundant,
but of no consequence, no use, either for him or for department.
Then, my lord, my lord may kindly peruse.
What course is you doing? Why is diploma the diploma?
Diploma in civil engineering.
Rules require 3 years civil engineering.
No, 3 years diploma, fine. 3 years diploma, but now diploma course can be done 1 year also.
But for the purpose he wants to do it, my lord, that the rules require 3 years diploma, my lord.
The rules are still holding the field.
Yes.
3 years
If he
diploma.
challenges the rules, my lord, it is brought down to 1 year.
But the fact is this, my lord, they have not raised this issue initially. Now only, my lord, afterthought. And these also, my lord, they have not enumerated in the affidavit. No averment has been made in the...
See, you don't need to make affidavits on the rules, I think. The rules are rules. Rules will be there. You can place any point of time. You don't have to put after this rules.
I bow down, my lord.
Speaking order regarding your representation, then that's brought on record.
My lord,
but if the rules are here, then what to do?
My lord, I bow down, my lord. But the fact
because
is this.
now you say that the very reason you are seeking to pursue this civil engineering diploma is to enhance your promotion prospects, correct?
My lord.
So that once you get that, then you'll be in the zone of consideration.
Consideration for SI work, my lord.
Yeah, but nowadays they say, look, now that border security, that SI works, whatever, now promotion, we have to have 3 year diploma. What to do? Is he entitled 3 year diploma to secure study?
3 years is not entitled, my lord.
But then where's the other one, the additional affidavit you filed? That fellow has been given for how long?
Only 12 months.
No, my lord, I think, my lord, they are trying to...
No, this is what he is annexed in the...
No, my lord may kindly see. This is the first document by which he was given 12 months, and my lord may kindly produce the payslip. From the payslip, it will be very clear. The 12 months plus 12 months he was given, 24 months.
Fine. That's fine. 2 years, not 3 years. Where is he now? He's retired.
I don't know, my lord, my lord.
His payslip doesn't indicate, my lord, he's on leave or something.
When I'm swearing on an affidavit, my lord.
That is immaterial. But then he's been granted. The fact remains that order exists.
Yes, my lord.
That he is granted 12.
But originally he was granted only for 12 months, my lord. And the department thought that it is useful degree. His diploma of 1 year, 2 years will be useful to the department they granted, my lord. He wants for his own benefit.
He'll be useful. He has a diploma. He'll have a civil
definitely I can deliver more.
You take instructions.
I will take.
Otherwise, he's continuous fitter only. Even he gets
let him supply me a copy of the rule which they are hitting me on. I will take the instruction, my lord. No, you're not given. That you have written.
Oh, they have forwarding of BS engineering civil combatant. You could.
Let me just see.
Then you'll have to. The whole dimension changes. In the course of the hearing, Dr. Enmozika has referred to the BSF engineering bracket civil combatant, then bracket again group B post recruitment rules 2013, which stipulate that for promotion.
Sir, his appointment was based on ITI.
BSF head constables engineering setup having 3 years diploma in civil engineering will be considered.
I will Take the instruction.
Submission, Mr. SD, please allow some time to.
My lord. Let it come on 5th of August, my lord.
Any date.
Let them supply me a copy of the rules, my lord. I will just see. I will take the instruction.
The diploma is 2 years or 3 years?
2 years, my lord.
2 years, correct?
2 years, my lord.
As of now, the new format.
There are all diploma. He has 6 months diploma also.
Oh.
In some fields, there are 6 months diploma.
No, for civil engineering, it's not a
2 months.
Course.
2 years, my lord. Because from the college, sir, they are writing to me, my lord. They have written to me that it's 24.
Only this is the first hurdle, my lord. The second hurdle, he's a fitter. He's a kind of civil engineering will not add any value to him. And it's beyond his
field. Goes to mechanical engineering.
Just go to something like mechanical.
So you apply mechanical engineering, Mr. D.
I will take the instruction, my lord. Now I have to change my entire thing.
You get 1 year mechanical somewhere.
Yeah. And mechanically, you may begin promotion.
That can be recorded also, my lord, so I can suggest him.
No, it's a fact. I mean, that if civil engineering will not, serve the purpose for your promotion, why pursue it?
My lord. I will take the instruction, my lord.
Yes.
Only, my lord, one small item, my lord, the day when it was called for mediation, my lord, Chalang M. Sangma, my lord, that matter of police where he was arrested and he could not join on that particular date. So I have taken the matter with the additional advocate general, my lord. He said yes, this matter can be referred to the agent. Today is the last day, my lord, where it can be submission can be. It was listed on Friday, my lord.
You were not here.
No, I was here, my lord. Government lawyer, they have an objection. That additional advocate general has instructed that this matter cannot be gone for mediation.
It is not here. The matter is not listed.
Then I will make a request tomorrow, my lord.
Yes.
My lord. Hello.
Okay.
Mediation can be any time.
My lord.
Program.
My lord.